Okay, understanding the liabilities of AI. Perfect. Okay, so just let me, but before I get started, Patrick, is your audio and video and everything else working before I jump in?
I think my audio is working. I'm gonna chat with Seth about my video.
Okay. All right. Well, I will jump in. So thank you, Seth. Thanks to everyone for dialing in. So I'm Andrew Burt, managing partner here at bnh.ai, and there we go. All right, we got video working, and Patrick and I are gonna really just walk you through the way that we think about managing the liabilities of AI and analytics. So this, if this works, okay, here we go. This is basically a roadmap for today's talk. What we were thinking of doing, I'll give you folks dialing in a little bit of a sense of like who we are and what we do. And then we'll do a high level, just kind of overview of where the liabilities from AI kind of come from, both from a legal and from a technical perspective. And then I think our plan is we'll pause there and we'll see if folks have any questions. Both Patrick and I will take turns talking, and we're happy to make this as informal as folks would like. So Seth, if folks have a question or they wanted to jump in, please don't feel free. Please don't hesitate to ask. There's really no bad interruptions. So.
All right. So I will say I
yeah.
have promoted 3 of our regular roundtable participants to panelists, and I know that 2 of them are prepared to engage with you about their own situations at the appropriate time. And then once again, other attendees, if you would like to speak, please use the Zoom raise hand feature, or you can use the Q&A, and you gentlemen can monitor the Q&A as well. Andrew?
Okay, that sounds great. And yeah, please don't be shy. So just a little bit about who we are and what we do. We're the first law firm jointly run by legal and technical personnel. There's only one place in the country where lawyers and non-lawyers can jointly run law firms. It's Washington, D.C. It's usually something that's used by lobbyists and lawyers to work together. And the thesis behind bnh.ai is that in order to properly mitigate the risks of AI and analytics, we need to commingle really, really closely different sources of expertise. The primary being technology, obviously, headed up by Patrick, and legal, headed up by me. We'll do assessments and certifications for models and programs, along with incident response when AI goes wrong. I'm not going to dwell on these slides. A little bit about myself, a little bit about Patrick, and together we founded the law firm. And I should just say that we're very young. While Patrick and I have been doing this as a law firm, we've been doing this for a very long time. We announced the launch of the law firm in late March. So that's a little bit of background about the law firm. I'll jump into the substance on AI if folks have questions about, why we exist or what we do or any of that or how we can help. We're happy to address that. So the problem with AI. So it really starts with this. This is a headline from the Harvard Business Review. Basically, I think giving a good summary of why there's so much enthusiasm around AI. And there's this general sense that if you're waiting as an organization to figure out how AI can give you a competitive advantage, it's too late. And so there's been this I think, pretty serious rush over the last few years to adopt AI, to embrace AI, to use data and algorithmic decision-making to create competitive advantages. And it can do that. We've seen it firsthand. There are a huge amount of advances that technologies like AI can help organizations generate. That being said, there are also huge liabilities, and we're seeing more and more every day. This is a headline from the fall in terms of discrimination in the healthcare sector. We've watched as security and privacy attacks on AI have increased and become more demonstrable. And then there was this headline, which folks might remember, where Apple got into some trouble with its Goldman Sachs co-branded credit card about discrimination. So there are a host of ways that AI and machine learning can lead to and amplify liabilities. And in particular, we view two major sources of risk. One of the things that I think makes this very tricky, one of the reasons why we started our boutique law firm, is because we've seen this in company after company of all sizes, is basically that the liabilities, the risks that emerge from AI are too complicated for any single team or any particular expertise to fully grapple with. And so it really ends up taking a combination of different teams and responsibilities and resources. So Patrick and I are going to dive deeper into both the legal and the technical side right now, and I'm going to start with the legal side. So I encourage our clients to think about the liabilities of AI as falling into really one of three categories. And I'm using liabilities here, and I have been pretty liberally, I should say. When I say liability, what I really mean is risk that a harm could lead to a lawsuit, a regulatory penalty, reputational damage. There are a whole host of liabilities that AI can create. So the kind of like the three pillars of this, I think, are discrimination, privacy, and security. From the discrimination angle, the way I would best kind of sum it up is that all models are biased. There's the statistician George Box that said that all models are wrong, some are useful. And the idea is that if all models are biased, it's going to be very easy to apply some of those biases against protected classes or minorities. There are privacy harms. The data that AI requires ends up, as is somewhat intuitive, having huge privacy implications. And then there's securities, there's security and attack surface. And as you can imagine, with traditional software systems, that creates one type of attack surface, basically like realm of vulnerabilities that an adversary could exploit. And with AI, and especially with models that can learn as they're deployed, the attack surface is just very, very different. And we found that organizations have a hard time grappling with these differences. So when we think about liability, we think about what laws exist on the books that are going to actually directly affect AI, what's going to create regulatory liability. I encourage folks to start with the FTC. This in particular comes from a note they released, the FTC released on its website in April. This was a few weeks in to all the stay-at-home and quarantine orders. And I think this is a note basically focused directly on the use of AI. And I'll dive in a little bit into some of how I would recommend folks think about their analysis. But I think the real takeaway is even in the midst of a global pandemic, even in the midst of all of this stuff that's going on, the FTC is sending these signals that AI is very much starting to be center on its radar. And I think that this is very, very interesting because I think this holds true with or without additional regulations on AI, which federal legislators have been talking about, and state level legislators have been talking about for a while. So a little bit of a deeper analysis into where I think the FTC is headed. There are really kind of, I think, 6 things that I think they're going to, 6, I should say, maybe metrics they're going to use to ask in terms of oversight for AI. So the first metric is they're going to want to know if the AI is making something that could be considered a credit decision. So there are a lot of existing laws on the books at the federal level, FCRA, ACOA, Title VII, that can be used to enforce specific standards for models that are used or foreseeably used in credit, employment, housing, insurance, and other analogous decisions. So that's really the first question they're going to be asking. If the answer is yes, there's even something called a furnisher, which means it's basically like one step down in the chain in terms of credit decisions. And so if the FTC can say that the model is being used to make something like a credit decision, that's going to create a de facto higher regulatory burden. I've been surprised as I've seen kind of the scope and the range of decisions that can fall into that. The second 2 buckets here, or metrics, are security and privacy. I think the major thing that companies are going to be asked is basically for security, what are reasonable standards and have you followed them in terms of securing your models? And then for privacy, the big question is going to be, what have you committed to? What do your privacy policies say? And are you doing anything with the data that's going into your AI? Are you doing anything with your models that might contradict either reasonable security standards or what you've actually committed to in your privacy policies. So these are kind of the first three metrics. I think it gets really interesting here. To start with here is misrepresentation. This is under the FTC Act. So as, especially we're seeing this with the pandemic, as businesses feel increased pressure to automate, especially automate with chatbots and other ways that they can automate some of their existing customer interactions. The FTC has signaled that it's going to be looking at whether or not customers could be deceived. And so from a legal perspective, this basically means, are there clear warnings and notices when someone is interacting with a model that is imitating human behavior? Sensitive data, there is a, basically as a rule of thumb, if a company is using sensitive data, if sensitive data is either training an AI model or is being fed into it once it's deployed, that's basically, you can think of that as a proxy for just an increased risk of regulatory oversight and liabilities. And then the last here is accountability. And I think this is really, really interesting because I think the question, this comes from the words of the FTC. Can you demonstrate independent standards or independent expertise that basically led you to step back and take stock of your AI? And I think one of the reasons why this is so interesting is because as this kind of regulatory landscape is evolving, we expect there'll be new regulations in the future, as I'll talk about shortly. And as the technology is still really, evolving, the maturity curve, I think a lot of organizations are still moving along the maturity curve. One of the things that regulators have hinted is basically if you have a third party who's looked at what you're doing and reviewed it, that in itself is a signal that you care. And they're looking at that as a signal of accountability. So that was in April. Just a few weeks ago, one of the FTC commissioners publicly released this statement. The second bullet here, I think is frankly just wild. Like in terms of looking for signals that a regulatory body is prioritizing, particular activities to oversee. It doesn't get, I think, more straightforward than this. So one of the commissioners said, just at the end of May, with the proliferation of machine learning and predictive analytics, the agency, the commission should use its unfairness authority to tackle discriminatory algorithms. So again, I think it's becoming clearer and clearer that even without new laws, the FTC is going to take an increased role in overseeing how companies develop, use, and deploy their models. And then before I turn it over to Patrick here, I think it's important. This is a heat map of regulations on data compiled by the law firm DLA Piper. It's a big global law firm. And I think one of the really interesting points about this map, which we've obviously been tracking for many years, is that most of North America is red. In the United States in particular is red, even without federal legislation on privacy, even without specific federal regulation on AI. And the reason it's red is because instead of one single standard, we have a very complex patchwork of sector-specific regulations at a federal level, which I've kind of talked about today with FTC. We haven't talked a lot about FDA or any of the other sector-specific ones. And then we also have states that are stepping into this gap. The CCPA in California, Washington State, there's a really important biometric law in Illinois. And so this breeds just a lot of complexity. And so the point here is really like, don't be deceived by the fact that we have, Congress hasn't yet passed an act that says, AI Regulation Act, because right now there's still considerable legal liability on the use of AI. And that being said, we are seeing hints. This seems to be one of the few areas that is very clearly bipartisan, which is, I think, saying a lot in the current environment. We're just seeing increasing, I would say, agitation, proposals, lobbying for new laws focused on AI, both from a general level and sector specific. So with that, I'm going to turn it over to Patrick, who will take the lead on the technical challenges.
Sure. And now might be a good time if anyone in the audience has kind of a burning question about what Andrew just presented. Now might be a good time to speak up, or we're happy to wait until after I get done presenting. And I think one thing that I'll add to Andrew's comments that was very educational to me as we started this law firm, is just simple,
Sorry, Patrick, sorry
Yep.
to interrupt. Are you able to speak closer to the microphone? We need greater volume.
Let's see. Let me turn my volume up a little bit. And is that better? Does this help?
Yes.
Okay. So just really briefly before we move on to the technical side of things, one thing that I've learned in starting this law firm is there are numerous sort of state and local, say, anti-discrimination laws that no one thought about applying to AI, but we've seen in certain cases that they can be applied to AI. And so I think Andrew made the point very clearly that we don't have to wait for the Algorithmic Accountability Act that's in both houses of Congress to start worrying about this. We're seeing enforcement action on the local level with laws that just AI can just break laws in general, and that's been a very interesting thing to learn. So I'll add that little bit of color commentary, and then I'll move on to the technical piece here. Okay, and then so Andrew's going to change the slides, and I'm going to try not to mess with my screen. So what is so different about AI from traditional computer systems? What is it that makes it different? What should we be paying attention to? And Andrew and I like to break things out into three. So here's three tidbits to think about. So whether you like it or not, machine learning is a branch of statistics. And as much as quote unquote data scientists and machine learning engineers want to forget that, it's just a matter of reality. And so machine learning systems can be wrong. They're often wrong. They're probabilistic systems. And so we just hope that they make more accurate decisions than humans. And you should be, that's one thing that I would urge people to test. Is this AI system actually more accurate than a human decision maker? And I think if people held their AI to that standard, we might not see some of the trouble that we see today. But anyway, the issue is machine learning or AI systems are just going to be wrong sometimes. And that's more complicated than regular computer software, because very oftentimes in regular computer software, if it's wrong, that's a bug, and that has to get fixed. And you figure out what part of the software is making it wrong, and you fix that. With machine learning, we just have to be willing to tolerate a certain amount of wrong answers, and I think that can be shocking, especially to sort of executives that are that had different ideas about implementing this technology. So another thing about AI systems is, they don't exist on their own. They typically are housed within some kind of pre-existing or additional application software, which can be extremely complex on its own. So not only do we have the hundreds of thousands up to billions that we have on the slide, different parameters or rules that affect any given decision that an AI system makes, that is embedded in an already complex and potentially insecure piece of application software. So the total complexity of any AI system is the complexity of its sort of application software, and then the machine learning itself. And there's a well-known quote in computer science or in computer security that complexity is the enemy of security. And so we're really complex with machine learning, and so that causes security and privacy problems.
Patrick, let me relate to you a question that Bill Nichols entered,
yeah, please,
which
please.
Really reinforces the complexity. Bill asked in the Q&A, what is your working definition of AI and of machine learning?
Well, I prefer for machine learning, I prefer the Arthur Samuels definition, which is essentially when a computer learns rules from data instead of a programmer programming in rules to a computer. The computer learns the rules from data. I don't particularly have a working definition of AI. I mean, we sort of use and abuse AI honestly on our slides, just like everybody else. So typically when I say AI, I mean machine learning. And I'll go with the Arthur Samuels definition of machine learning, which you can Google. Yes, and so just defining what these things are is hard enough. It's hard enough, and I take that point. And another thing that I think can surprise people about machine learning is it decays over time. Its quality decays over time. The quality of decisions it makes is based on a snapshot of reality that it learned from at training time. And as we drift away from training time, then the way that it's able to make decisions is based on old data. And we all know that making decisions on old data can lead to weird outcomes. And so that's another feature of AI. And you might be thinking, oh, well, I can do adaptive learning. On the slide, we have probably the world's most famous example of adaptive learning, which was Microsoft's Tay chatbot, which was hacked by, I'm not sure if it was coordinated or uncoordinated Twitter users. And this is really just a great example of what can go wrong with AI. And luckily it's kind of silly and no one was really truly hurt. I mean, she said some horrible things, but it didn't crash the economy or something like this. So what happened with Tay is Tay was getting feedback from users and users poisoned her. Users started saying horrible things to her and she learned to basically repeat them back. And she tweeted something like 96,000 times in 16 hours. And in the end, before they took her down, it was mostly just pornographic and horrible, hateful, white supremacist things. And no one coded pornographic or white supremacist statements into Tay. Those were learned from data, they were learned from users, and she drifted into that territory. So AI drifts, and this is another thing that makes it very different from sort of traditional software. Even if the code stays the same, the answers change, and that's a tricky thing. Andrew, feel free to add, or if you want to change the slide, we can just keep trucking.
The one thing that I would add is just from like a liability side, I think Tay is incredibly important, because if you went to Microsoft before release and said, what have you done? Have you protected yourself? They would probably have said yes. And if you went to one of the data scientists and said, did you program Tay to be a white supremacist? They would say, of course. There's nothing in there. We would never do that. So I think it highlights how easy it is for some of this stuff to surprise organizations. So that's it. I will.
And we're talking about one of the world's. I think that's a good point. Microsoft Research is one of the world's leading authorities on machine learning and artificial intelligence. However we decide to define that, Microsoft Research would be, a place with one of the places in the world with the most experts. So again, it's just a really interesting example. But I guess we can go to the next slide. All right. So because it's so complex, it's often not transparent how the outcome, the decision that the AI or machine learning system makes, it can be very opaque. It can be very difficult to understand how a decision was made. And as Andrew was kind of hinting at earlier by mentioning the financial services regulations like ACOA and FCRA, that's Equal Credit Opportunity Act and Fair Credit Reporting Act, in those sectors, decisions about lending have to be explained to consumers. So just giving someone a yes or no answer out of a black box is already illegal. And I think that's a good thing. Unfortunately, in other spaces and very high stakes spaces, that's not the case. And there was a write-up in the New York Times, what's become a very notorious it's probably not even machine learning, but a very notorious algorithmic system known as Compass, which is used to score people to decide if they should be paroled or if they should have pretrial detention. So there's a case that again, written up in the New York Times, 2016. The man's name was Glenn Rodriguez. His inputs into the black box Compass system were wrong, and he was denied parole several times. And I guess just because he had a lot of time on his hands, he was able to figure out what was going on. But think about this. You have some very high impact, high stakes life decision, and all you get is a yes or a no, and with no sense of appeal, and no sense of how the decision was made. And that's really troubling, and something that we urge our clients not to do, and something we would urge everyone not to do, and something to watch out for, in your interactions with AI and machine learning. So decisions need to be explained, and they need to be explained so that they can be appealed or overridden by the operators. So the security and privacy vulnerabilities, these are really complicated, and I'm not, I don't want the discussion to get too technical. So I'll just give an example of one, and there's something known as a model extraction attack. And this is where essentially someone gets a copy of your model. And, you may be thinking, well, what's the big deal if somebody gets a copy of your model? Well, if your model is a deep learning model with 10 million weights in it, then it's basically memorized your training data. And there's ways to extract your potentially sensitive training data. With your model, people can understand your proprietary business logic. And so you have this nasty mix of security and privacy problems. So I sort of gained unauthorized access to sort of proprietary business IP, intellectual property. But then also when I got that model, I got some kind of, either fuzzy or maybe even really good copy of your training data, and I violated privacy, I violated your user's privacy now. And so AI tends to mash up security and privacy issues, and that is, and security and privacy are very difficult to handle on their own. And when you think about combining them, it's very, very tricky, complex situation. And the last point here on discrimination, I don't think anyone wants their machine learning system to be, something that contributes to perpetuating discrimination. And the way this happens in machine learning, like Andrew said, is, the training data that we collect oftentimes reflects social biases and known discrimination. And if you're not actively working to counter this, it's very easy to encode discrimination into your machine learning model and then perpetuate that discrimination out onto your users. And again, this is something that is basically illegal today in the United States under different federal laws and different local laws. And you would think that the companies as well resourced as Apple and Goldman Sachs would be able to get this right. And I'm not sure there's been a regulatory ruling on this, but there was certainly enough going on there with Apple and Goldman Sachs that it got people's attention. And so we have two of the most resource-rich companies in the world building a predictive model around lending, and they're somehow today giving, at least originally before they corrected it, they were giving men something like 10 times the credit limit of women, which is just well known to be illegal in most cases. So it'll be very interesting to see how that turns out, and that's a very interesting situation where you have these two very, very companies that should have been able to get this right. So I'll leave it at that, and I think Andrew will pick back up on the next slide, and maybe now's another good time to pause and see if there's any questions from the audience.
Any questions? Our roundtable members who are as panelists can just speak up, or other people can raise your hand under the participant screen and I will enable you to speak.
I have a question if you don't mind, Seth.
Go ahead and please introduce yourself, Jared.
hi guys. Thank you so much for the presentation. I really enjoy it. I'm a lawyer in Baltimore, and I have a company that makes legal chatbots that they're kind of like the front end for a lot of different law firms, but primarily in immigration. And I have a number of questions for you, but Patrick's most recent sort of discrimination question is the one that kind of piqued my interest here. One of the things that our bots do is when it turns out that a potential client isn't a good fit for the law firm with which the bot is speaking, it calls out to the other bots on the network and sees if any of them are able to perform that task. And then if there's more than one law firm that can fulfill that task, we're trying to sort of figure out what kind of algorithm we're going to throw at picking which of the law firms we decide to use with the recommender system. And what we were thinking about using was, who has the better conversion rate in terms of when we pass that lead over, what law firm is better able to convert. And it occurs to me that one of the reasons that a better firm could convert would be because of racism or other discriminatory factors. So how would you begin to address this sort of business conversion versus a potentially racist conclusion, especially when I think a recommender system is a very good example of what would probably be a black box?
Patrick, do you want to take this, or you want me to jump in?
Yeah, I can. Can you hear me? Sorry, I was having some bandwidth issues. I would say, so I'll when I get done talking, I'll send you a link because there's an entire sort of academic sub-discipline around discrimination and recommendation systems. And of course, that'll be a lot of impossible to read papers, but maybe you'll find something useful there. What I'll say is two things. There are standard tests today that you should likely be doing for discrimination, and these have names like adverse impact ratio or standardized mean difference or just just checking the accuracy across different users of your system, right? Like are you able to send female users to the best law firm at the same rate at which you're able to send male users to the best law firms? So standard tests for discrimination should be applicable to your system, and maybe that's something that we can talk about offline. And then two, there's almost no reason for machine learning to be a black box these days. There's a lot of newer approaches that are highly transparent, and I think that they would even apply to recommendation systems. So I'd question that premise that a recommender has to be a black box. And again, that may be something that we can talk about in an email or something like that. There's been lots of good research recently on how to make machine learning systems more transparent. And just very quickly, I'd say you don't want to mix up explaining how your machine learning system works with testing it for fairness. Those are sort of different tasks. And that's a technical subtlety, but I'd say the most important one would be to test for discrimination. And again, there are some sort of standard tests that you should likely be able to apply.
And I'll just to follow up with just, I don't know, more direct lawyerly reaction. I think have a plan and follow it. Yeah, so two parts. One, have a plan for trying to understand if discriminatory behavior is happening, and then two, just follow it. It might sound a little silly or basic, but the number of, it's just very, very, very easy to say we'll deal with this when, well, we're not going to do anything overtly wrong, and we'll deal with anything bad that happens, once it happens. And that's a recipe for disaster. So just like the very, very basic level is to think about what you consider discrimination, have a plan, have a testing plan, and then follow it. So if something, one, hopefully it means you can avoid bad things happening at all, but two, if something does happen and if there is an incident, you'll have some defensible kind of legal positioning. So thank you, really, really good question.
Hey, this is Shelley Blake-Pluck, Yet Analytics. I had a question. A lot of this presentation has been from the point of view of care that companies and developers should take. What I'm interested in is where the law is and where it's evolving in the public space, especially around AI use cases like computer vision in public areas and computer vision related to autonomous vehicles. Where is the law and where is it going in terms of available hacks that can be done on computer vision systems in public spaces, whether that's something like concealing identity from cameras, or whether it goes as far as altering environments to mess up autonomous vehicle systems that rely on computer vision.
So really, really, really good question. I'm not sure. Part of the so to be upfront, there is no answer yet. I'm going to try to give you an answer, but there is no answer yet. And one of the reasons there is no answer is because while it seems like you just asked a question about AI and data privacy and data security, you also are asking a question about free speech and the First Amendment and what people have the right to do in public. And so that's why that question is so tricky. Now, it's different in the United States than it is in the EU and in other countries. But in the US, that question of like, what does the law say you can do to interfere with an algorithm that is just kind of like passively receiving data, gets really, really complicated. So there's some papers that if you want to reach out, we have our contact information at the end of the slide. If you want to reach out, I'm happy to send you some papers on it. But frankly, the major act that criminalizes activity in cyberspace, the CFAA, the Computer Fraud and Abuse Act, it's not entirely clear what that type of attack, how that would be criminalized under the CFAA. I think that being said, so it's a really interesting question, and there's a lot of like interesting research and scholarship. That being said, just to get to like the bottom line there, I do not think that does not justify the conclusion that someone could hack, you know, like the studies on hacking machine learning models. There's a prominent one where they did it with, I think it was Tesla Autopilot, and they put some black stickers on a stop sign, and that caused it not to see the stop sign. So what I just said, the fact that the law is unclear and the CFAA is unclear, that doesn't mean that if someone does that intentionally to a stop sign or creates some real harm, that there aren't going to be legal penalties. It just means that the exact way that, you know, existing data laws apply are not yet clear. And so I would bet money that in the next couple of years, there are either going to be direct amendments to the existing criminal statutes, or there'll be something new that applies more directly to AI.
Shelley, do you have any follow-up there?
No, that was a great response. I appreciate it. Thank you.
Great. Heidi, you had a question. Do you want to unmute and ask that?
Yeah, thanks so much for making me a panelist. I didn't really want to ask a question so much as I just wanted to put it out there. People want to know, what can they do? And one solution is to just think outside of the box. If you are wondering how you can make your AI design more inclusive, conversations between white people is going to yield software that's good for white people. So if you want to make it more inclusive, you should be more inclusive in the people that you bring in to represent our language. So it's a social justice project that was done at Safe Labs at Columbia University. but it's also one that can show that it was profitable. It made jobs. It was good for the communities, and it had positive results because they abided by the Social Worker Code of Justice. So they didn't really share the data with the police, but they did have community activists get involved and reduce violence. So chatbots can be used for a variety of things. When it comes to data privacy, I think the federal legislation is going to be the best way to do it. But if you're going to set your browser to the privacy settings, you're going to have one browser abide by that. And right now the browser is the problem. So your AI is going to follow behind whatever they do with the browser. So follow platform law to see what's going to happen next. So if everybody could check out that project and like think bigger and outside of our field, we could make more jobs and make better and more inclusive AI. Thank you.
Heidi, do you have a link that you can post to the chat?
Sure did. It's already in there.
Oh, okay, good. Andrew, Patrick, you want to respond?
Yeah, so
Just really, sorry, Patrick, go ahead.
No, you go ahead.
Oh, just, yeah, I would second that. I mean, our central thesis is that different types, you know, as a boutique law firm, is that different types of expertise need to be in the same room together. So the more types of expertise, the more types of people, the more types of from every category, I think the better. There is one really difficult question that I'll just raise. I don't have the answer. I know that right now there's almost never enough diversity from almost every single angle in the room when a lot of these systems are being built. And one question I think about a lot is when is enough? When can we feel satisfied that the right voices have been involved? And that's an answer it's a question I don't have an answer to. But I certainly would I would second what you say, and I'm excited to take a look at that link.
Yeah, and so maybe we should get back to the slides, because we do have a slide about what you can do to fix these, and certainly demographic diversity in projects and diversity of experience and diversity of background is a major process best practice.
So Andrew, go ahead and restart your share of the slides.
All right, so I guess that's a signal that we should keep running through the deck. Patrick, unless you have something else to add, I'll just jump back into it.
No, go for it.
Okay, cool. So, all right, so we've been talking about the problem with AI, the liabilities, the risks. We'll now basically talk a little bit about just like how organizations actually end up bearing the costs for some of these liabilities, and then we'll close with some recommendations. So this is how, let's see. Okay, so this is how we like to think about the risk cycle of AI. You know, this is what we encourage our clients to think of, and you have kind of like T-2 all the way on the left. That's the beginning, and then time 2 on the right is recovery. And in the middle, you have an incident, which could be an internal failure of the system, or it could be one caused by an external malicious adversary. And I think the key question, or I guess the key takeaway, is that when organizations are thinking about AI risks, they have a decision to make. That each of these is in its own right a decision point, and companies have a choice. Organizations have a choice to think about when and how adoption takes place, and where the decision lies in terms of mitigating risk. And so you can decide as a company that you're just going to do most of your risk mitigation, at T2. If something bad happens, you'll figure it out. We see a lot of that, frankly, with startups that are just trying to get a minimum viable product to market. As I'll say shortly, like, we don't recommend that. But I think the key is that companies and organizations have a choice, and it's their choice to decide at what time they want to really seriously think about risk. And again, just quickly, when we talk about incidents, there can be a variety of causes. Just kind of like back of the napkin overview, models can be hacked, they can be manipulated, they can act in ways that are discriminatory or simply inaccurate, and then they can more overtly break the law, and of course more. And so I think, I should highlight Patrick and I, just a few weeks ago, we wrote an entire article, kind of headlined here, on what to do when AI fails. And the real kind of goal is to encourage people to think about what, organizations to think about what are they going to do if their models fail, and to have plans in place before then, so that they're not just kind of reacting. And connected to that, there are costs associated with this decision. And so if you're an organization and your decision is just to wait, it means that if something happens, really when something happens, because of the probabilistic nature of machine learning, it's going to be a lot more expensive. And so what we encourage our clients to do is think about these risks proactively and try to get as far to the left as humanly possible, so that they can avoid these harms, and with a consequent kind of reduction in costs. So it's in everyone's interest not to just wait. And again, we see this all too often. It's where we typically get brought in once something has gone wrong. Frankly, it's typically when people call lawyers, they wait for a fire, they wait for something to go wrong, and we would just highlight that. I think if you can walk away from our presentation today with one takeaway, it would be that it harms everyone. It's bad for organizations, it's bad for the public, if you're waiting for failures to occur before you're planning for how to mitigate them. So that's the cost. And then in terms of what you can actually do as an organization, we basically, I think it starts with asking the right questions. And so we have 3 of them here. We're going to be releasing something actually later this week called 10 Questions on AI Risk with a nonprofit called the Future of Privacy Forum. But to start with, there are 3. And the first is just inventory, which boils down to, do you know how and where your AI is developed and used? This seems like a basic question, or it seems like it should be a basic question. It's really, really not. We see organizations struggling with this in all sorts of different forms. Second question is oversight. Basically, who is overseeing the process in which your models are trained and deployed? And then the last is readiness. Where are your plans for AI failures? What are you going to do? Who gets called internally, externally? How are you going to mitigate reputational risk? How are you going to mitigate risk on your customers? So just having plans in place, like we mentioned earlier, is a huge signal that an organization is actually ready to take on the risks associated with AI. So a little bit more detail. I'll let Patrick talk through the slide.
Yeah. So I think this highlights, hopefully, some of the points that Heidi was making. We certainly would recommend having a diversity of experience on any team that's making a high stakes AI system. I think the key is that there are actually a lot of things you can do, though. We kind of divide things into technical buckets and into culture buckets. And to highlight another issue on the culture bucket that I think I saw fly by in the chat, I see a lot of advertisements for psychology apps these days, and I always wonder, was there even a psychologist or social scientist involved, or was this really just a bunch of 25-year-old white guys in a room who read a blog and wrote an app? And I think we'll just have to find out the hard way, unfortunately, the way things are right now. But hopefully in the future, these kinds of things will be regulated, or more people will be educated about it, and we'll avoid these kinds of problems in the future. But I think another key here is, as I look at all these sort of technical solutions and cultural solutions, is they're all connected, right? And so you can think about security and fairness being connected. I may do all the testing I can and have all the best people in the room when I make the system, but if I release the system out into the world and then it's hacked to be discriminatory, I've still failed. And so privacy, security, discrimination, accuracy, stability, the business processes, they're all related, and they're all necessary to get this right. And that's why it's so difficult to get it right. And it does take beyond sort of legal and technical expertise, but we oftentimes hear the complaint about no social scientist in the room, and that's something I've seen in real life for sure. So there certainly is expertise required outside of just technical and legal. I think I'll stop here. I see we have just a few more minutes for questions. This is the slide is basically what Andrew and I do. So if you have questions, I think, please follow up with us after the presentation, and then I'll shut up. So maybe we can get one more question in right now.
We can take a bit more time, if you guys are available. I'd say up to another 15 minutes. I will remark in response to something you just said, Patrick. I ran a conference a month ago in the beginning of May called the bnh.ai conference, and I had a panel on data bias and ethics. And one of my panel members was Sarah Jordan, who is with the Future of Privacy Forum. So we got into these kind of questions, but the idea behind Emotion AI is that you're using technology that can be textual analysis via natural language processing. It can be voice technologies that understand the pragmatics of speech, how you speak and not just the words, and also very controversially facial coding technology that looks for expressions of emotion. There are fundamental questions about whether the models that are being applied even work, whether they have scientific validity. So when you're dealing with human data, especially, these questions are very relevant. That's two of the things you said. Vineet Sachdev, you're on the program now. I think, would you like to say something about?
Yeah, I was waiting to jump in. So yeah,
if you wish.
Sure. Yeah, I was waiting to jump in. I think there were a bunch of questions ahead of me. So yeah, I think it would be helpful to get some insights on like AI assistants in highly regulated domains like healthcare. I mean, those tend to be very closed. So some of the issues that you were highlighting, I was struggling to kind of apply them to healthcare, but there are other things that probably need to be worried about on healthcare. So I was just wondering what your observations and point of views are. I mean, there is quality. I mean, before getting FDA approvals, there are like you have to convince them about quality management systems you have in place. How do you kind of validate a new release? What kind of studies you've done to demonstrate the clinical benefits or the value proposition and so on. So I was just wondering if you can share some thoughts around some of these issues as they apply to healthcare or medical software as medical devices specifically.
And before you guys answer, Vineet, your work is in?
So I'm the founder and CEO of Endovigilant. We do computer-aided detection and diagnosis for endoscopy procedures. So these are very highly visual medical procedures that physicians perform, and we sort of augment what they see so that they can do their job more efficiently and more accurately.
Yeah, so really, really fascinating question. In fact, because of all of the stuff that's going on with the pandemic, we've started to give some more tailored legal advice within the healthcare space. And so it's a question that I think is just increasingly like near and dear to my heart. So I'm not sure if you're familiar with it. You said software as a medical device. So the SAMD kind of phrase, but last year the FDA released a discussion paper on how it could have kind of a more modern approach to AI and machine learning in particular, and software as a medical device more generally. There have been just some really, really deeply fascinating examples in just the last year. For example, Germany, I think in November, authorized physicians to prescribe software, actually tying into some of Patrick's psychology asks. So there is an increasingly interesting connection between, and I think more and more direct connection between the actual provision of medical services and software itself. And I think regulators know that. There have been, I kind of like, this is like a separate conversation. I'll point you to one resource, and I could spend hours talking about this because I think it's so fascinating, and frankly, personally, I think it is very frustrating that a lot of people in the tech space are kind of disincentivized to apply some of this technology to healthcare because the liabilities are so great. And so as a law firm, like that's what we're here to do. And so I wish more technologists could get involved, and I wish that the barriers to entry were not as great. But so anyway, the one resource I would point you to, just a few weeks ago, a few law professors and researchers attached to Harvard released a proposal in Nature on how the FDA could more rapidly think about approving AI and machine learning based diagnostic and therapeutic technologies. And the core of their argument is one that I believe in, and I think that this is where the future is going. In fact, I think there's a direct line between that FDA discussion paper and the article I'm mentioning. And their basic view is that the way that regulators are going to approach this is they're going to look at these applications from a more systemic view. So they're not going to be approving individual models. They're going to be looking at broader systems. And I think it's just a very fascinating space. And a lot of that ties into, I think, some of the more general advice that we were giving on the FTC, like auditing and thinking about the types of practices that are not necessarily model specific, but that can signify a high degree of care. Sorry?
Sure. Yeah, no, I think that's great. Yeah, no, I had come across that paper that you alluded to, but there wasn't much activity after that. I think the one that I think I saw you put that up when you were showing your slides as well. The one that FDA released sometime last year, I think.
Exactly. Yeah, and I can. Yeah, again, please. I want to. Before we end, I promise to share a slide with our emails and some of the resources. And if you're interested in talking more, like, again, this is a subject that's really, really, I just think it's really deeply important.
Sure, thank you.
And I'll add, I've seen research, much like Seth was bringing up, on the social science side, this perhaps, questionable idea of emotion recognition. I've seen the same thing on the healthcare side for tumor recognition. I mean, Andrew and I were doing some research on this for a different project, and there's real questions on whether deep learning models are actually able to identify tumors safely in medical images. As much as the hype that you hear about this, when push comes to shove, I think some of the people are still unsure if these systems are as accurate as people claim they are. And one sort of suggestion we came up with there is, again, keep a human in the loop, human review of AI systems, If a medical system or other high stakes system is making a really important decision, it probably that decision almost certainly needs to be reviewed by a human, and maybe it's more it should probably still more likely be the AI augmenting the human. And I know that's not really regulatory commentary, but that's what came to mind when I heard your question.
Let me raise for your reaction another observation. I attended an online program yesterday. Actually, it came out of the United Kingdom, although some of the participants were not British. It was put on by the All-Party Parliamentary Group on Artificial Intelligence. And one of the participants and moderators was a member of a British Parliament. And the topic of the program was facial recognition and emotion analysis. And it was quite interesting to me. I was speaking earlier, for instance, about emotion analysis from voice. You can equally use technology, AI technology, to identify individuals based on their speech patterns and the words they use and all kinds of things. For that matter, we have computer vision technology that can look at your gait, how you walk, in order to uniquely identify individuals. But these people, including this member of parliament and the scientists and people who are academics studying these fields, they didn't even seem to really understand that there are technologies out there that can be used to recognize individuals in the public sphere or in shops, wherever they are, and to analyze things like emotion. They didn't recognize that these technologies exist other than facial coding. And, I can speculate that they focused on facial coding because video cameras are ubiquitous in the United Kingdom. They're all over the place. And so that is sort of top of mind. But on the other hand, we're all carrying around these devices that capture our voices, and many of us use smart speakers and all of that kind of stuff. And the potential for abuse there and misuse of the technologies is just enormous. So my comment is that the people who are writing these regulations, they have very incomplete views, and some of the academics that they're consulting have, let's call it, very narrow views. Yes. Where they see only particular technologies. Your reactions?
Very quickly, I have a lot of reactions to that. So one is, the last time Seth and I met, I was running product at a very prominent Silicon Valley machine learning software company. And the reason I left that job is because of exactly what you're bringing up. I just cannot feel comfortable with these technologies that can fail and be abused in so many ways. I don't want to contribute to the sort of proliferation of these technologies until we can get the regulation and the ethics of it sorted out. And I have no, I won't comment on the ethics. I'm not an ethicist. I understand the technology, and I understand how the technology can be misused and abused. So yes, these issues are at the top of mind and very important to me. And I see this not only, in the application domain you're speaking about, I see it everywhere. And then also, my second comment, everywhere that machine learning is applied, and any kinds of high stakes situation where machine learning is applied, I don't think that it's not, sometimes the regulators are great and there's other problems. Sometimes it's the regulators' problem, sometimes it's the attorney's problem, sometimes it's the technician's problems. There's rarely a case where everyone gets everything right in these scenarios, and that should be very concerning to all of us. Second, I agree that the academic focus is very, very narrow. I've observed almost a war between people who study fairness and people who study explainability and people who study security. It's like, if you read a fairness paper, it's only about fairness. It's never about explainability or security. If you read an explainability paper, it's only about explainability. And, as someone who sort of has an academic affiliation myself, I understand what's going on there and the tremendous stress and pressure the researchers are under, which is unfortunate, because all of these things happen together. Fairness is connected to security, is connected to interpretability, is connected to accuracy, is connected to the business processes. So those are my reactions. I'll let Andrew jump in.
Yeah, so I'm happy to, I could talk about that endlessly. One thing I just want to plug, if I may, is just some resources we recommend, and then I want to make sure people see our email address so that they can reach out directly. So just a few resources that we would recommend. 10 questions on AI risk. We're going to be releasing that later this week. But in the meantime, if you want it before it's online, you can just email this or us. Then there's what to do when AI fails, and then a few different white papers that we've released in the past year. And then just importantly, let's see if I can get this. There we go. So this is, if we said anything that folks are interested in or want to follow up directly with either of us, here are our emails. So just to make sure we got that out there. In terms of facial recognition, I agree with what both of you said. I think it's a deeply concerning technology, but I also think that facial recognition on its own is not what concerns me. I'm concerned with just automated identification. And that can come from facial recognition. It can also come from voice recognition, gait analysis. And so it's a much broader problem. As we generate more data, it becomes easier to identify us. And so I think there's something a lot more basic that we need to address if we're going to really kind of tackle what I think our root concern is. You could ban Face ID, ban all facial recognition everywhere. You're still going to have a variant of the same problem as long as we're generating more and more data. So great.
Actually, there's an instance of a problem that I just read about. I think it was yesterday afternoon or this morning, again involving Microsoft, that they turned on automated content analysis, and they stopped using humans to do an editorial function, and they confused two mixed-raced individuals who are in a band. I'm not going to go Google this right now in order to find it, but this stuff is just going on all the time. And the attitude with many technology companies, and for that matter, the individuals, the organizations that are applying technology, is, hey, let's just do it without sufficient forethought.
I have a question for you two from the sort of just do it camp, actually, that might be a little bit from the other side. And it's that I think this has been brought up a lot in the context of self-driving, but I'm going to bring it up sort of in the context of chatbots, is that, humans do a terrible job of so many things, and we're not even talking about regulating them. We're not holding them to these standards. And then suddenly AI, in the form, in this case, of a legal chatbot, raises its hand and says, hey, I can give sort of 24/7 in your language free legal advice that's highly accurate. And the lawyers that I'm dealing with and the general public as well, they sort of say, well, if there's a possibility that this bot actually makes a mistake with its legal analysis, which is sort of ludicrous when you compare it, to the fact that many lawyers make legal mistakes. But then even worse is that the bots aren't really competing with humans a lot of the time. Who they're competing with is people just Googling and then reading blogs and then making their own legal conclusions, which is sort of like, seems to be much less accurate than an expert system taking a crack at it. And so I guess the question is sort of, how can we handle this idea that it seems like there's more, the better you get at actually answering people's questions and doing things, the more your liability goes up, compared to people that are really doing a bad job with, like, sort of a loose YouTube video that someone might just take all the advice in it and act on it. And then and then even maybe could we get to a threshold where I could say to my customers and sort of across the board, look, this is more accurate than X, and that's why we're able to release it.
I think you just hit on the key point, right? And I kind of brought this up when I started talking. I wonder if how often people compare the machine learning system to a human expert, and if it's actually better. Now, and you also brought up another, and some of the points you brought up are philosophical, and yes, humans are wrong too, and there's laws about people, we all know that, but I'm not really qualified to comment on that, but you're certainly right to bring them up. So my other comment, though, is you said 24/7, 365, and that is where you have to watch out with machine learning. Okay, no person, like the chatbot. Okay, no person can tweet 96,000 times in 16 hours, right? So what you have to think about is, and I don't want to discourage you, because it sounds like your heart's in the right place. Now I can't say what you're doing is legal or not, but you're a lawyer, so good for you. So what you have to think about is the scale of the decisions, and very often that's where you get into trouble, right? Say because this happens to me all the time. I'm changing some program and I have an idea right before I go to bed. I get push, and then I check back in the morning. So what happens if you get push and you break something, and that break causes a discrimination or privacy problem, and your thing's running all night and it's your busiest night ever, right? Like so I think it's the scale to watch out. I think that's the real, like, a person can only be wrong so quickly. A machine learning algorithm can be wrong, 200 million times in a day, something like that. So I'm not arguing with you. I don't want to say, I just want to point, that's my counterpoint, I guess.
Yeah, I would say so. Patrick took the words right out of my mouth. There's a reason. Well, so yes, scale is it. But I would also highlight that I think kind of like, I don't know, allow me to read between the lines there. I think there's a little bit of a frustration like embedded in your question. I think that the frustration comes from the fact that, like, when is good enough? Like, when have I, there's all this value attached to this thing I'm building. When will the lawyers kind of just like shut up and say, like, this is, even if we are lawyers, like, when is good enough? And so I think there's an invitation to be strategic about this. I think there's an opportunity here. I think there's a huge danger, but I think if organizations are strategic, they can answer these really, really, really difficult questions like to the left, well before anything bad happens. I mean, frankly, it's part of why we exist is figuring out how to get the right technology to market safely and responsibly. And the answer, the answer is certainly not, in our view, just get it to market and see what happens. That's a recipe for all sorts of bad things. But the answer is equally not wait and do nothing and just, you know, talk and write more legal memos. And so there's a balance. And I hear you in the frustration coming out of a technology startup. So anyway, I get it. It's really difficult. I would just really, really, really encourage you and other folks not to let the frustration drive you, because there's stuff here that you just, you don't want to get wrong as an organization.
Here's a practical piece of advice. Here's a practical piece of advice for people who do want to innovate quickly, right? Like, we can't all be giant companies with all these process overheads and things like this. Have an incident response plan, okay? If you want to innovate quickly with machine learning, you should be planning for it to fail. Have a response plan. And that's something that, Andrew and I wrote that O'Reilly article about, but we'll be releasing some very detailed materials about AI incident response over the coming weeks. So we can share those with Seth. And I would say, this is the piece of advice I now give to people who either want or need to go fast and break things. And it's just have an incident response plan.